Proposed case number 25-20560. United States of America versus Michelle Brannons.
Good afternoon, Your Honor. Sarah Cohen appearing on behalf of the United States.
Good afternoon.
Your Honor, I'd like to introduce myself. I'm John Rogers, appearing for Michelle Brannons.
All right, thank you. And ma'am, if you could give us your name, please.
Yes, sir, Your Honor. It's Michelle Brannons, sir.
All right, thank you. And before we go any further, I need to advise you of certain rights that you have. You have the right to remain silent, which means you don't need to say anything to me or answer any questions anyone asks of you, and anything you say can be used against you. Do you understand that?
Yes, sir, Your Honor.
All right. You also have the right to the assistance of an attorney at all critical stages of your case, including any time you're in court and any time authorities question you. Do you understand that?
Yes, sir, Your Honor.
All right. And first, I think we're going to be taking care of the arraignment on the indictment. I have your signed acknowledgement of the indictment, indicating that you understand that in count 1, you're charged with conspiracy to commit forced labor, and that as to that charge, if you were to either plead guilty or be convicted, you would face up to 20 years in prison and or a fine of up to $250,000. Next, in each counts 2 through 7, you're charged with forced labor. And as to each and every one of those charges, if you were to either plead guilty or be convicted, you would face up to 20 years in prison and or a fine of up to $250,000. And then lastly, in count 10, you're charged with conspiracy to commit money laundering. And as to that charge, if you were to either plead guilty or be convicted, you'd face up to 20 years in prison and or a fine of up to $500,000 or twice the value of the properties involved in the money laundering transactions. Also, if you were to be convicted of more than one count, you could face consecutive sentences, which means one sentence on top of another instead of them running at the same time. Do you understand all of those charges and the potential penalties, ma'am?
Yes, sir, Your Honor.
All right, thank you. And Mr. Rogers, your client waives formal reading of the indictment?
Yes, sir. We enter a plea of not guilty.
All right, thank you. Then I will enter a not guilty plea on your behalf, Ms. Brannon. And now we need to take up the issue of bond or detention.
That's correct, Your Honor. The government has moved for detention in this matter.
Okay.
And this is the date and time scheduled for the detention hearing.
All right. Then I'll first hear a factual proffer from the government and then factual response from the defense, and then each side can present argument.
Your Honor, may the government confirm that the court has received the brief that was filed in this matter?
Yes, I read both the government's submissions as well as the defense submissions.
Thank you, Your Honor. If I may, I'm going to start with a brief introduction, and then I will move into the factual presentation. As this court is aware, Congress requires that a presumption of detention be applied to the defendant who was charged with forced labor. As the Sixth Circuit stated in United States v. Stone, the presumption reflects Congress's substantive judgment that particular classes of offenders should ordinarily be detained prior to trial. The statutory presumption helps victims of forced labor recover safely and securely from their physical and emotional harm and from their trauma. And Congress was right that leaders of forced labor crimes are particularly dangerous defendants, as proven by Michelle Brannon's behavior for 11 years. Michelle Brannon was the Lieutenant General of David Taylor's brutal regime. According to the evidence, she literally is a serial sadist who engaged in physical and psychological torture. Behind the locked doors of call centers in Michigan, Missouri, Florida, and Texas, Brannon was the enforcer of every order and every punishment. Forced unpaid labor, denial of sleep, denial of food, denial of medical care, physical assaults, and threats of violence. For 11 years across 4 states around the country, she terrorized victims of JMMI and KOGGC. Victims who have escaped her and David Taylor, defendant number 1, have described their fear of her and the trauma she has caused them. As evidenced by just a sampling of her orders to her victims, such a depraved and dangerous defendant should not be released into the community. For example, at 5:31 a.m., Michelle Brannons sent a text message to several members of KOGGC, specifically the media team, including victim number 3 in the indictment, stating, "Media team, no going to sleep until the mosaic video is done!" Exclamation point. On another day, 7:10 a.m. in the morning, Brannon, unhappy with the manner in which a worker was soliciting donations, sent a text stating, "Did you rebuke him for this? He needs to be raked over the coals for this. He can die for this!" Exclamation point, exclamation point. On another day at 11:46 p.m., Brannon texted a group including victim number 2 in the indictment. From Apostle, meaning David Taylor, warning, tent and garage judgment starting tonight for 7 days. If after 7 to 14 days there is no change, it's the public shelter for 1 solid month. At 4:57 p.m. on another day, which should be the close of business for an ordinary, normal work environment, Brannon texted a group including victim number 2 in the indictment. Warning from Apostle, again, David Taylor. Top 6, your low numbers each day. It has to stop now, in all caps. You will be punished constantly until you obey and train your heart and mind to obey the training. Brannon's leadership is also documented in recorded staff meetings. For example, in March and May of 2023, Brannon said, We have to tell them to turn in their stats every hour and get on them. Give them consequences, taking meals. Yesterday, I was so irritated seeing, and we had to take food away or give them bland food for just seeing some of them raising 200 and then 400 over the course of 6 hours. And these are people who know how to raise money. And again, in another staff meeting, she's recorded saying, "What makes me so angry is for people to be dishonorable to you," speaking to David Taylor. For example, she's heard saying, and she gives the name of a worker who the government will not identify in a public forum. "The worker in the middle while you began the meeting," referring to Apostle, "when you started the meeting, he or she went into the weight room and fell asleep. He was awake when you first started the meeting. How he got by non-executive and all of the staff, he went into the weight room and fell asleep during your meeting. These are the type of stuff that's going to kill people. Why did he fall asleep? Because he was sleep deprived. Or she. Why did she fall asleep? Because she was sleep deprived." Again, the government is not identifying who Michelle Brannons was referring to. As the sampling of text and recordings demonstrate, Brannon was the lead enforcer of JMMI and KOGGC, not the mere victim of David Taylor. Brannon was particularly known for a traumatic punishment called rebuking, which she references in the text message that the government recited to the court. Rebuking occurred when any of Brannon's workers failed to meet a monetary quota, disobeyed Taylor or Brannon, or violated any rule imposed by Taylor or Brannon. During a rebuking, Brannon or someone ordered by her got inches from the face of a worker, screamed at them, and called them names like stupid, dumb, wicked, Nigga, and Lucifer. Many times, victims were forced to kneel and repent to Taylor and to God. Rebukings could last a few minutes to a few hours, depending on the situation. Many were done in public in front of other laborers as a form of public humiliation. Again, in the presence of Michelle Brannons or someone ordered by her. In addition to being the lead enforcer, she was the financial leader of the criminal activity. She was given this position of trust by Taylor in part because she was the best at manipulating callers into giving donations. She was so good, she was called the top closer. And she was so good at manipulation that she trained her victims to extract donations from callers. In addition to being a manipulator, she is a liar, even to court officers, as the government detailed in the brief. She lied to pretrial services in Tampa when she was arrested. She was arrested with approximately 57 workers in the mansion in Tampa. When she was interviewed, she said she lived with her son and 6 coworkers. That is a blatant lie. She also lied to pretrial services when she stated 2 of the workers were living with her in Tampa were her employers. That is not true. She is the employer. David Taylor being defendant number 1 employer, Michelle Brannons being defendant number 2 employer. Because she's been leading JMMI and KOGGC with Taylor for so long, she is unable to live a life devoid of KOGGC work and workers. As a best-selling author and expert in leadership wrote, life is work and work is life. They are inextricably intertwined when you are a leader like Michelle Brannons. This is why there is no appropriate bond address or bond conditions for her. Releasing her on bond with the condition that she has no contact with witnesses or victims is literally impossible for her to comply with, Your Honor. She will continue the only life she knows, which as a KOGGC worker manipulated by Taylor and Brannon said during a Sunday broadcast recently, quote, "We're in a war. We're in a war, and it's time for you to decide if you're a warrior or not." Releasing her, 2 members of KOGGC and JMMI who have not yet come forward is like releasing the lieutenant general of a war back into battle. I will explain how this is so with each of the bond proposals submitted in the brief filed by the defense and also as requested by Brannon. First, I will go through the names identified at times in the defense brief and at times by Michelle Brannons. For the record, Your Honor, the government elected not to put these names in a public filing, but of course for oral argument, I'm going to refer to them by name. The first suggested contact is Ms. Kirsten Jones. She's also known as Kia Jones. The evidence has shown that Taylor has entrusted Kia Jones with carrying out punishments since at least 2021, as the following text message demonstrates. At 10:21 p.m., Taylor texted to a victim, "Michelle and Kia, make them all stand and tell them if the punishment of 4 a.m. don't work, and I'm going to make it worser and worser. They are going to get their beds out of my house and sleep in the garage. Everyone piled in there. This ruthless boot camp is going to get worse and worse until they do what we are telling them. There will be only soup, bread, and water for the degenerates every day, nothing else." Jones' significant and continuing role in the organization has been confirmed by a recent interview of a victim who came forward after the execution of the search warrants and Jones' own statements and actions recently. She has been on the Sunday broadcasts asking for donations at the conclusion of the service. Those broadcasts are continuing, and she remains an integral part of those broadcasts. She also is posting on social media. There are a number of examples, Your Honor, so I will just point out a couple of them and why she is a wholly inappropriate contact for Michelle Brannons. This was on September 21st. "Hallelujah, we serve a mighty God. Apostle David E. Taylor is coming out of this fiery trial and won't even smell like smoke. Michelle Lynn," which is Michelle Brannons' current name, "is coming out of this fiery trial and won't even smell like smoke." Another social media post from Ms. Jones. "I became a full-time missionary in 2015 under Apostle David E. Taylor's leadership. My life has been more than I ever have prayed for." And again, another Facebook post. This was on August 31st, again after the execution of the search warrants. "So glad to be back on Facebook, so I can tell the world I stand with my general and spiritual father, Apostle," referring to David Taylor. So, that is Ms. Jones. Moving on to Amanda King, Charles Smith.
Is Ms. Jones alleged to be a victim of KOGGC?
Your Honor, the government's position is that every single person who works for KOGGC or JMMI is a victim. Whether they have come forward and admitted to themselves and to the government that they are a victim is another question. But yes, everyone who works there is a victim of David Taylor and Michelle Brannons.
And where are they now, these 50, however
Ms.
many?
Jones is right here, Your Honor. She can address, if the court wants to address her, she would categorize herself as anything but a victim.
All right. I guess I don't understand where, you said there were 57 people residing at this mansion?
That is correct,
It's
Your
the
Honor.
government's term. You called it a mansion. Is it a real mansion
Yes.
in a residential community?
Yes.
Is there barbed wire and guards around the mansion that would prevent anyone there from leaving of their own free will?
No one is allowed to leave the organization of their own free will without the permission of Michelle Brannons and David Taylor, Your Honor. These people are here today because the government executed a search warrant at that address and released all of the people in the organization. Some people chose to be here and support Michelle Brannons. And one of those individuals is Ms. Jones, but as demonstrated by the evidence and by her Facebook posts, she is entrusted and has been entrusted with carrying out some of the punishments within the organization. So she is not an appropriate person for Michelle Brannons to have contact with. That is not how we ensure the safety and security of the other victims who are attempting to heal from their psychological and physical trauma.
Have any of those other victims seen medical providers and have medical records documenting any sort of physical harm or otherwise?
Your Honor, I'm not going to get into the details of victims' medical records. I don't think that's appropriate in a public forum.
I'm not asking you for names.
I can represent, Your Honor, that the government has corroborated with substantial information the victim accounts of physical assaults.
And just give me examples without names. When you say physical assaults, are there
Sure.
people with broken bones? Are there people with knocked out teeth? Are there people who are emaciated from not having nutrition? I'm just trying to understand the facts behind the allegations of severe physical abuse.
Your Honor, to be clear, the government has alleged psychological and physical abuse, sleep deprivation, food deprivation, denial of medical care, denial of contact with the outside world, the forced labor carried on in a number of different ways, not just mere physical abuse. But I'll give you an example because it relates to another person that Michelle Brannons has proposed to live with, and that's Mr. Joseph Bush.
I'm sorry, what was the name?
Mr. Joseph Bush. The government has information from a witness that Joseph Bush was witnessed by a number of other victims physically assaulting a male member at the direction of Michelle Brannons. I'm simply giving one example, Your Honor. Again, this is Michelle Brannons' proposal of an individual that she should have contact with when she is on bond. This is an individual, again, that the government has evidence of physically assaulting individuals within the organization. And again, I'm not going to be tied to a specific number for purposes of a proffer. So I can certainly provide additional information about Joseph Bush, but to answer your question, he is one of the individuals who has been seen assaulting another member at the direction of Michelle Brannons. All right, moving on to, we've discussed Kia Jones. I'm going to continue to discuss Joseph Bush because that is an individual who has been proposed by Michelle Brannons. Joseph Bush admitted to the FBI on August 27th, the date of the execution of the search warrant, that he was one of the leaders of the organization, and he actually admitted that he was, and I'm paraphrasing, the third person in charge of the organization. Shortly after the execution of the search warrant, he went to a Chase bank to access accounts. He was not able to take out money because the government had frozen the accounts, but he did go to a bank, and he did so because he is a signatory on many of the accounts. He's been in the organization for a long time, probably about 10 years. He's a lead host in online events. He posts on Facebook, and most significantly, Your Honor, Joseph Bush was with a number of victims at a victim services center in Tampa during the execution of the search warrant. There were a number of victims who wanted victim services. They wanted to speak with the government, and they wanted help from victim services. Without going into great detail, Joseph Bush was present at that location and encouraged those individuals, I will use that term lightly, encouraged individuals not to seek the help of victim services and not to speak to the government. And those individuals ended up leaving the center that was set up to help these people. So that's Joseph Bush. Another individual is Amanda King. Amanda King was proposed in the defense brief. She is a long-term member. She is very close with David Taylor. I will leave it at that. She operates multiple Facebook accounts, some under different names other than her own. She supports Taylor and KOGGC from the accounts.
Excuse me, I'm going to object to that. That's a mischaracterization of what was noted in the brief. All that was noted in the brief about Amanda King is she subleased a piece of property in this jurisdiction should the court find that preferable over the original suggested location of Tampa Bay, Florida.
Okay.
All right,
Well, I guess the thing I'm not understanding is pretrial services in their recommendation, number 5, is avoid all contact, directly or indirectly, with any victims, witnesses, or co-defendants. And so it would seem to me that the government should be able to identify those people, and we can craft if the court is inclined to release the defendant on a bond, you can identify the individual she's not to have contact with, and you say, well, of course she's going to. She won't be able to abide by that condition. But if there's a condition and the defendant fails to abide by it, then there's grounds to move to revoke the bond. But I guess I'm not understanding why really the government's point in light of that condition that she not have contact with any victims anyway.
Let me try to explain, Your Honor. This organization has been in existence for decades. Michelle Brannons joined the organization in 2013. The number of people who have been involved in this organization is a list that the government simply cannot provide at this time. It is impossible to provide a comprehensive list of people that Michelle Brannons cannot have contact with. So the point of the government's proffer today, and in response to the defendant's request in the defense brief, is to identify those people that she wants to live with, those people that she wants to have contact with, those people that she has proposed to have contact with and to live with, and how those are not suitable individuals for a number of reasons. In addition, there are no people outside of this organization that the government is aware of that Michelle Brannons has reliable contact with. There are not. This has been her life since 2013. So the court is, respectfully, I'm suggesting, the court is setting her up for failure. And that is not appropriate in a presumption case, 1. And 2, it is very scary and traumatic for those victims who have come forward and are depending on her incarceration for their safe and secure rehabilitation. Again, there's a reason why Congress has applied a presumption of detention to this case. And it is on the defendant to produce evidence that she is not a flight risk or that she is not a danger to the community. And that has not been done. Well,
I only asked a couple questions, and
well,
I haven't reached any conclusion, but at the same time, it would be inappropriate, I think, to not recognize that the pretrial services officer in Florida recommended a bond with fairly minimal conditions, and our pretrial services officers have recommended a bond with very extensive conditions. and the government's factual proffer to this point has been fairly lacking in detail about the type of actual harms that are alleged. And I read everything in the brief, and there's just not a lot of facts.
I respectfully disagree, Your Honor, with regard to the lack of specificity when you consider both the details in the indictment, the details in the brief, and the details that I provided during the course of my proffer. But since you've referenced the pretrial services reports both in Tampa and Detroit, let me go through those and explain how Michelle Brannons has lied to the officers and why the recommendation is not appropriate. So beginning in Florida, the government has already explained how she lied to pretrial services there, both in the nature of her living situation in Tampa and the nature of her employment. So it is, although it is surprising that they recommended bond, it is in part because she misrepresented her living situation and her employment situation to that pretrial services officer. To the extent that the defense proposed that was some misunderstanding, the pretrial services officer filed an addendum in Florida confirming that the pretrial services officer reached out to the defendant's employers, Joseph Bush and Kia Jones, and that they returned the call. So there was not a misunderstanding. She misrepresented who her employers were. She is the employer of Joseph Bush and Kia Jones. Now that she is in custody, they are taking on a more active role in the organization and furthering the activity. I will leave it at that.
Are they under indictment?
Sorry?
Are those individuals under indictment?
Not in the current indictment, no, Your Honor.
All right.
Moving on to the current pretrial services recommendation, Your Honor. Again, pretrial services, it is not necessarily their role to acknowledge the presumption of detention, but I am here to remind the court that the presumption applies. She references, again, she's misrepresenting to this pretrial services office the nature of her friends and her caregivers. She references Ms. Kia Jones and Mr. Joseph Bush. At no time does she tell pretrial services that they are members of the organization, and not just members, but that they actively carry out punishments to victims and that they are continuing to be not only involved in the organization, but asking for donations to the organization. She does not tell pretrial services that. She requests, moving on, she requests that she live either in the Tampa mansion or an address in Northville, Michigan, but she fails to explain to pretrial services, of course, that the residence in Tampa where she was arrested was a forced labor call center that was the subject of the execution of a search warrant. And she doesn't know this, but I'm here to represent to the court that that property is now in the process of being seized by the government, so it is not an appropriate place for anyone to be residing. For
Your Honor, I object at this point in time to another misrepresentation to the court. I represented to this pretrial services officer these very allegations that have been blamed to my client.
You'll have a chance to share your side.
Yes, sir, I'm sorry.
That's okay.
So specifically, Your Honor, the government has filed a lis pendens against the mansion. So it is not locked by the government, and technically someone could go in and reside there if they wish.
Well, who's residing there right at the moment? Anybody?
There are individuals there, and thank you for asking, Your Honor, because I was just going to get to that. There are individuals who are residing there, and that is a concern in the neighborhood. The neighbors do not want people associated with this organization residing in that mansion. It is an affluent neighborhood, and the neighbors are very concerned about people who are coming and going. Again, I don't want to publicly identify him, but there is I will call him a victim/witness who is currently residing there. And law enforcement has observed this individual coming in and out at various times of the day and driving a car to and from the residence. So again, this is not an appropriate place for her to be residing. The address in Northville, a number of concerns about that address, Your Honor. First, it is a rental property. Michelle Brannons has no income. Her only income came from KOGGC. So the question becomes, who is going to pay for that rent? The government submits to the court that donors to the organization will be paying that rent, and that is not an appropriate place of bond for her. For that reason, because she has no money to pay for it, and also because it is approximately, I will just say, it is in proximity to what the government will refer to as a women/children's house, where some of the women and children in the organization are currently residing. They are, I don't want to identify how far apart they are in a public forum, but they would share commercial and shopping areas. So it is not an appropriate place for Michelle Brannons to be living. That would be very frightening for the people in the community. And again, there's no information as regarding how she would pay the rent and the utilities, et cetera. There is another individual also who is proposed by the name of Charles Smith. And again, I don't see that request by Michelle Brannons. That's a request by the defense. So I can reserve a proffer regarding Mr. Smith if that remains a proposal by the defense. But the point of this proffer, Your Honor, regarding bond is that there isn't a person that Brannon can be with who is disassociated from this criminal organization.
She doesn't even need to be with anybody, though. There's the pretrial services isn't recommending, doesn't saying, well, she can be released only if she's in the third-party custody of somebody else.
Well,
right?
True, but the defense is requesting that she be given care by individuals who are still a part of the organization. So I guess I'll wait to hear what the defense argument is. But again, with regard to several conditions of bond, Your Honor, even if the court were inclined to let her live alone at some house that she has no ties to and has never had ties to before in this community, again, as the government pointed out in its brief, the only tie that she has to Michigan is her criminal activity. She has no legitimate ties to this community whatsoever. The ties that she's creating are ties to her criminal activity, period. So even if she were to live alone, where would that be, one? And two, the bond conditions that would be imposed are impossible for her to comply with. Literally impossible. She knows no one outside of the organization. She will have contact. She needs money. She needs food. She needs people to assist her. And there is no one who will do that except people in the organization who are either witnesses or victims to her criminal activity, to David Taylor's criminal activity, and to perhaps other leaders in the organization.
Okay.
So I have other information to provide, but I understand that I have been talking for quite some time. And if the defense would like to clarify what their proposal is for bond, then I would like to reserve time to respond to their proposal.
Okay. All right. I guess the floor is yours. Go ahead.
Your Honor, I was a little confused. I thought what the court asked from us initially was only to speak to the issues of statutory considerations with respect to bond, not preemptively argue about potential hypothetical, theoretical government violations of a proposed bond that is yet to be ordered by the court. So I can take as much time as Ms. Cohen did arguing factually and disagreeing with her facts, but I thought your direction to both of us was to simply deal with the issue of bond itself and the law and the statutory considerations therein. So that's where I'd like to start. Thank you, first of all, by recognizing that 2 independent pretrial services reports took a look at the indictment and all the theory and conjecture put in the indictment, all the theory and conjecture and lumping of Ms. Brannon with another individual, and alleged violations of non-charged potential co-defendants in this case, and section that out to look at the statutory considerations, which are very simple, and the court's well aware of them. The Bail Reform Act, Section 18 U.S.C. 3142, does presumptively require that I produce a burden, I have the burden of production to satisfy the court as to the issue of release, but the government retains the burden of persuasion, citing U.S. v. Mercedes, which you've already reviewed, and I won't get into. That burden is very simple. My obligation is to produce evidence that she doesn't pose a danger to the community or doesn't pose a risk of flight. What the government fails to brief in the 65 pages that you reviewed was that they seized her passport, and they're in possession of that. They allege she has access to financial assets, which they've seized, accounts which they've seized. So the only assets that she has with respect to continued assets is about $2,200. So there's not a lot of money there, and the government has her passport. With respect to the danger to the community, the government always takes this position and has taken it in this case that she's a danger to the community, but Congress itself set forth, even in presumptive cases like this, specific crimes that they're more concerned with as opposed to others. Generally speaking, those are crimes of terrorism, crimes that involve minors as victims, controlled substances offenses, like the one the gentleman who received bond earlier was charged with, firearm cases, and explosive cases. None of those are forced labor cases. What Ms. Cohen did is she explained her theory of prosecution in great detail, which sounded like argument to me. The government's always very arrogant in their approach to their evidence in their case in these pretrial detention hearing cases. I haven't been provided with
I wasn't saying anything was arrogant.
I was. I am saying, generally speaking, the government takes and this is not a personal attack, Mrs. Cohen is a professional to deal with, but the government takes an arrogant approach to the weight of the evidence consideration that is before you. One that, as a defense attorney at this preliminary stage, has been confronted and has been proven to be false in every acquittal in every criminal court case across this country time and time again. The weight of the evidence in this case, I will tell you, without any evidence being presented to me whatsoever, I have dealt with, I concede and I'm aware that at the Tampa Bay particular residence, there was a number of people that were detained by the government and pressured by the government to no longer participate in the religious church and the religious activity. They were told the government's theory of prosecution and felt threatened. Many of those individuals have fled. Many of those individuals are defense witnesses. Many of those individuals have scattered across the country in fear of being rounded up and treated heavy-handedly by the government as they were treated during the arrest of Ms. Brannon in this particular case. And many of them will provide, and I have interviewed some of them already, their willingness and continued desire to continue to exercise their First Amendment constitutionally protected right to worship. So I will not speak to that in great length or get on that soapbox, but I will take that up. This is an opportunity to challenge the categorization of all of these victims. My understanding is there's only 8 or 9 individuals that are claiming to be victims in this case, and I agree with your characterization. And the people that I've talked to, there has not been any evidence presented to me from my point of view that one of them received any physical harm that caused them to do any particular thing, as in report to an emergency room and or complain of being injured in a serious physical way. So when you look at the government's indictment, it does talk about psychological harm. There were no walls around any of these call centers. There was freedom to exercise one's right to leave at any point in time. There's a group of individuals in support of Ms. Brannon who have come to her aid here today who will say there's a number of ex-church members that will be valuable defense witnesses at the trial that we intend to have that will support the contention that you can come and go as you please and that you can maintain respect for the church and a common worship outside of the confines of the institution itself. And I say confines, I just mean the different places of worship around the country, some of which were being used as call centers to reach out during the ministry to a variety of individuals. I don't want to try the case in front of you today, which is what I believe the government has spent most of their argument trying to do. I will look to point out to the court what my burden is with respect to making the initial threshold to try to convince you that bail is appropriate. I look to the very same factors that your pretrial services report looked to. I would point out my client's in ill health. She has had a cardiac event since we had a recommendation from a jurisdiction in the Central District of Florida for bond with minimal conditions. We waived the opportunity to have a detention hearing there so we could get back to this jurisdiction and make this argument before you. During the time period where she was incarcerated, she was hospitalized no more than 3 occasions for 6 days. She had a mild heart attack. They had to undergo a cardiac event where they put a stent in her heart, and the recommendation given to the Marshal Services, based on my understanding from the detention facility and the medical officials, was that she seek the attention of a cardiologist upon her release. She has no prior arrests, no prior convictions, certainly no 3 prior criminal convictions. These are allegations. Certainly we understand when you look to the indictment, and I won't repeat all the lumping that the government has attempted to do in their argument today with respect to text messages to third parties and individuals that are not currently charged with any criminal action of any sort. There are, with respect to the risk of flight, I've already noted to the court that the government has their passport. She has no access to funds that are any bank accounts right now other than $2,200. She is not unlike any other potential defendant on bond in this jurisdiction and across the country. Yes, she has access to credit cards. Yes, she has access to PayPal accounts, etc. Maybe she will or maybe she won't receive support from individuals that are associated with the church to maintain her lifestyle. Maybe as a condition of bond, this court will tell her to get a job. These are all arguments for conditions of bond, and we will adhere to whatever conditions of bond you think and to be deemed reasonable in this set of circumstances. There is a protective order issued in this case currently. We have consented to that protective order. As a practical matter, that's not a leading consideration for the court. But if the government suspects or has any theories that their case could be compromised in any way, we've done all we can at this stage of the game at the request of the government to protect the integrity of the investigation by not disseminating any discovery or any material or identifying any potential victim or witness. What I can tell you from third-party interviews, and I can't validate the substance of this, but that some of the government's own complaining witnesses who are alleged in the indictment are acting as government agents by reaching out to other members that were associated with the church who have since left the church to see if they will join them in litigation moving forward. So, all that being said, I don't think I need to go through all of the issues that I briefed or didn't brief. I think U.S. v. Valcourt mandates your consideration as to whether or not there are any conditions or combination of conditions of release that will reasonably assure her appearance, the integrity of this procedure, and the safety of the community. A potential neighbor that doesn't want someone living next to them in a viably rented home where no one else will reside is not a valid reason to deny bail.
So which home are you talking about when you say that? The one in Northville?
The one in off of 7 Mile in Michigan. I don't know who the neighbors are. I haven't had the time to speak to them, and they're, quite frankly, the argument's an irrelevant one.
Is that the principal place where you're proposing that she reside on bond?
I'll defer to you. Her medical the reason we suggested the place in Tampa was because all of her, with all the medical issues that she has, the arthritis, the vertigo, the heart issues, she has doctors in that area. There's no one living there currently, not a single person. Of the 30 people that are alleged to have been there, no one lives there. We were simply proposing two individuals live there with her. One is her 22-year-old son, and the other was Miss Jones, who is affiliated with the church, but she's not charged in this offense. And we only suggested her because she has a track record and history of providing transportation and intimate knowledge of her physical situation, and routinely transported her to the doctors. But we defer to you in this issue with respect to that, and I would like an opportunity, certainly, should you choose to give us bond in this case, in conjunction with everything that's been recommended to you by 2 pretrial services offices, that I'd like to be able to have some input as to those conditions, but we would respect and adhere to all of your decisions with respect to this argument moving forward.
All right. All right, anything else?
No, sir.
All right, Ms. Conga, you can go ahead.
Thank you, Your Honor. There are a number of facts that need to be corrected. Adriana Didel will be speaking with regard to access to assets because the defense's representation is incorrect. And I will let her do that in a moment. With regard to the defense's representation that there was no place locked or surrounded by a fence, that is incorrect. The principal call center for the last several years was located in Houston, Texas. It was a former hotel, Your Honor. David Taylor bought the former hotel. He converted it into a call center. He moved his workers there, not all of them, but many of them. It's surrounded by a locked fence. There was an armed security guard, and no one came or went from that former hotel. No one. When the FBI executed a search warrant in Houston, Texas at that call center, they had to enter in part through the roof for their own safety because it was that heavily armed and that heavily secured by a fence. So the representation that people could just come and go as they please.
You say that heavily armed. There were people with firearms, guards?
There was at least one armed security guard, Your Honor, who was.
You said heavily armed, as if it's like some sort of army base with machine gun turrets all over the place.
I didn't mean to suggest that, Your Honor.
That's the suggestion when you say it's heavily armed.
Yeah, I will clarify.
And how often was this defendant at that Houston location? Ever?
I don't want to disclose that information right now, Your Honor. Suffice it to say that as a leader in the organization, David Taylor allowed her to stay in the very nice mansion in Tampa. It was a luxurious property for Michelle Brannons, not for the laborers and workers who live there, but for Michelle Brannons it was. And so that's where she was allowed to take residence because she was number 2. She didn't stay at the hotel, which wasn't as nice. The other workers and other victims stayed at the hotel, which was surrounded by a fence and an armed guard. And no one could leave, get medical care, get food, see their families, or do anything without the permission of David Taylor or Michelle Brannons in that location. So that representation is just inaccurate. So, again, in any trafficking scheme, Your Honor, you have victims who have wide-ranging reactions to their physical and psychological abuse. Some are ready to come forward and tell what happened to them. Some are not yet ready to come forward. The execution of these search warrants was just August 27th, merely 30-some days ago. So it also is inaccurate to say that other witnesses aren't coming forward, and it is quite natural for victims who have elected to come forward to encourage other people who have been similarly victimized to have the courage to come forward, especially if defendant number 1 and defendant number 2 are incarcerated, so they feel safe coming to the government and telling their story about victimization. In trafficking schemes, victims will not come forward when they have been so severely psychologically traumatized and in some cases physically traumatized. And again, it doesn't always mean that they were punched, although there were physical assaults. But when you are so sleep deprived that you describe the feeling that you have as in a fog and you can't even think straight because you're not sleeping and because you're not getting proper food and because you're forced to do everything that Brannon and Taylor tell you to do, it takes some time to remove yourself from that situation and not be afraid of David Taylor or Michelle Brannons any longer. So the government is asking that this court incarcerate Michelle Brannons, defendant number 2, so that the community is safe from her. And because the defendant has not met their burden of production, quite frankly, and our burden of persuasion has been overwhelmingly met. The only thing that we haven't discussed today yet is her access to assets. We did reference that in the brief some, but Adriana Didel can address in detail the mischaracterization. She has access to far more money than just the $2,200 that the defense represented.
That is not what I represented, Your Honor.
Right, well,
I apologize if I heard it incorrectly, but Ms. Didel can explain the access to assets.
But is that the extent of your factual proffer about this defendant's actual involvement in the wrongdoing here? And I'm just trying to understand. I mean, looking at the indictment, like page 7, says she required the victims to work long hours without pay. I mean, what does that mean?
Exactly what it says. She required.
Did someone point a gun to their head? Were there? I mean, I don't know. There's just, and then today is the hearing that is supposed to establish by clear and convincing evidence that the defendant is a danger. This is just an allegation, and it's a very vague allegation. And so I was expecting to hear perhaps testimony, perhaps victim statements, perhaps medical records without names, but some details about this situation. And I mean, I understand how terrible it sounds on paper. That's not lost on me, the kind of cult environment that it sounds like, and but that's not evidence. And so I just wanted to be clear that this is, that's my expectation for this hearing, is that I was going to hear the evidence behind the allegations that would demonstrate by the required level this defendant's dangerousness.
Your Honor, for purposes of a detention hearing, the government proffers, which is what we are doing today, and we should clarify for the record that a grand jury has found probable cause for these allegations. The grand jury heard the evidence supporting all of the allegations, and they found by probable cause that these facts occurred and that Michelle Brannon and David Taylor were responsible for them. This forum is not the place to try the case, and it is certainly not the place to bring victims who have been traumatized by Michelle Brannon and David Taylor to hear that this court might be releasing her.
I'm not saying to bring the victims here to testify live. I'm saying to proffer facts that you have heard from the victims about their alleged experiences and to provide details to the court, and so the court has the full picture of. I have no idea how many people are at these call centers in Texas. All I know is you said there's 57 people at in the Tampa location. I have no idea where they are right now. I have no idea what any of them say about the defendant. Apparently, there are a handful of them here today, right here in this courtroom, supporting the defendant. And I don't know if the government is contending that each and every one of them is a victim and they just don't realize it. I don't know any of that. Maybe they are. I'm not foreclosing the possibility that sometimes I think, like in domestic situations, there's often a victim and that person doesn't realize it. But I'd need to know the facts to be able to assess and make a decision about whether there's any place where she could be and not pose a real danger to anybody.
Your Honor, there is a presumption of detention in this case. The burden then switches to the defense to produce evidence that she is not a danger to the community or a risk of flight. They have not done so, especially when the court will allow Ms. Didell to speak to the assets that Michelle Brannons has. Only if they produce evidence that she is no danger or no risk of flight does the burden then switch to the government to persuade you that
right,
she is.
The burden on the defendant at that stage is relatively light, and a defendant with zero criminal history can proffer the fact that they have zero criminal history. She's 50-some years old, I believe, so she's lived 50-some years without incurring any criminal history whatsoever. That alone, I think, is sufficient to rebut the presumption, and then the presumption still remains as a consideration for the court, I understand, but it's just, I don't know, the standard that applies is clear and convincing evidence, and so I'm just being upfront about, what I'm looking for to understand what this defendant's actual danger is or isn't, and I haven't made any decision.
Your Honor, she has no criminal record in part because she's been in this organization as a leader since 2013. That's over 12 years that she's been in the organization, engaged in brutal criminal activity that is just now being charged. So the fact that she has no criminal history really is not as significant as it might be in another case. Here, it is not significant. I don't mean to be dismissive of her lack of criminal record prior to I shouldn't say 2013. She joined the organization prior to 2013, but she became a real leader in 2013. So, she's for 12 years, she's been engaged in sophisticated money laundering and a sophisticated scheme of forced labor where she's depriving people of sleep and food and medical care and contact with their family, and they take away their phones so that they cannot communicate with family. So if they want to leave, they have no way to reach their family and say, I am being forced to work here, I cannot leave, please help me, please call the police. They cannot do that because their phones are taken away. So there is no way for these people to communicate with family and reach out for help. And if they don't comply with an order, they are further sleep deprived, they are, the food is taken away, and they are rebuked, and sometimes they are shoved in a garage in Florida with no air conditioning until David Taylor and Michelle Brannons decide that they have suffered enough and can come out of a garage in Tampa and come back to raising money for the organization so that Michelle Brannon and David Taylor can live a life of luxury. This is not a church. This is not a church that benefits a community in any way that a legitimate church benefits a community. This church is not a church. It is a forced labor scheme and a money laundering scheme where people were victimized for decades, and they were kept behind a fence in Texas after David Taylor bought that property. They were kept in a mansion in Florida.
And what's the tie between this defendant and the Texas place? How do I know that she even knew about it or had anything to do with it?
I'm proffering that she, as number 2 in the organization, she was responsible for everything. And as delineated in our brief, she's the signatory on nearly every single account. She knew as the financial leader of that organization. David Taylor wasn't really the financial leader. Michelle Brannons was the financial leader. She knew how every single penny was spent in that organization. She kept track of every single thing that was bought and every single thing that was spent. And she and David Taylor talked about every property, every gift for women, every transportation of a woman to David Taylor, every gift to a woman that David Taylor wanted to be with. Michelle Brannons knew about every single penny. And I'm not going to try this case during the course of a detention hearing, and I'm not going to describe in this forum. I'm not going to describe in this forum all of the government's evidence because this isn't a trial. This is a detention hearing. And the purpose here is to persuade you and to persuade any court that the presumption of detention is properly applied here because of all of the factors that we delineated in our brief. And I can go through them again, but the penalties that she's facing alone, Your Honor, gives her significant incentive to flee, a significant incentive to flee. And again, that's delineated in our brief. There's a base offense level, and the government went into great detail the guidelines that apply to her. So if you're not currently satisfied with the detail of the facts, we can go through each one of the factors and explain how forced labor in and of itself, we're not even talking about the money laundering, the forced labor carries such a significant penalty that it gives her an incentive to flee. But I do want to give Ms. Dydell an opportunity to describe for the court the assets that Brannon has access to, because that is significant and part of the reason why this defendant should be detained. Ms. Dydell.
All right, go ahead.
Thank you, Your Honor. As this court is aware, the government must only show by preponderance of the evidence that the defendant creates a risk of flight. And in this case, that is just the slightest tipping of the scale. As this court knows, this case that we can easily show that. Michelle Brannons.
I'm going to object to a second prosecutor making the same arguments as the first one.
It's not the same. This is going to focus on just the financial aspect.
That's correct, Your Honor. Michelle Brannon was a signatory on every single one.
Have you seized the accounts?
We have seized 5 bank accounts. We seized the funds that were in those accounts on the date that the seizure warrants were executed.
Okay. Are there any other accounts that have not been seized?
Your Honor, there are. There is the government has a warrant to seize Bitcoin, which we have not yet located. Ms. Brannon has access to a Coinbase account. Theoretically, she has access to Bitcoin of at least $35,000. As of yesterday, when we checked, that Bitcoin is still available.
Okay, but she's not going to go very far in $35,000.
And I object to the term of theoretically. This is a fact. This should be a factual hearing where facts are proffered to this court.
It is a fact that the church has a Bitcoin account with approximately $35,000 of currently valued Bitcoin in it. It is still available on the blockchain as of yesterday.
Okay, but that's not going to, like I said, that's not going to get her very far.
The organization is continuing to hold Sunday services. At the end of every
Who's holding the Sunday services when she's been in custody for the last?
Other individuals who are involved in the organization. At the end of every service.
Which is protected by the First Amendment to the United States Constitution. It's called freedom of religion.
Again, it's just...
I have not finished my thought. So if I could have an opportunity to finish my thought, maybe you will understand where I'm going with this.
Okay, go ahead.
At the end of every service, they ask for money. That money has traditionally been solicited through Cash App, PayPal, Venmo. Those are the exact sources of the funds that went into the church's bank accounts. Michelle Brannons has Cash App, Venmo, and PayPal accounts still in her name. She has the church, members of the community who provide payments can provide payments to these accounts, which could provide a significant amount of assets for her and with which she could flee. In addition, this organization does not use only traditional means of holding their assets. As the government's brief shows, starting at page 19 and continuing on page 20, there were significant other assets not outside of financial institutions that were recovered when the search warrants were executed, including significant amounts of jewelry, gold bars, gold and silver coins. There are additional vehicles. There are potentially other assets out there that are at locations that the government has not yet searched that are available. As we have proffered, Ms. Brannon knows where all of the financial activity of this organization, where all of the assets are, and because she controlled the financial activity.
Okay.
And for those reasons, I think that she has access to assets as well. And I should add, other individuals which have been proffered as potential individuals she could reside with have received significant money wires to their accounts. And those individuals also have received significant funds from the KOGGC organization. Anyone that she is in contact with within this organization could easily get funds which she would have access to.
Okay.
And for these reasons, I think she is a significant risk of flight.
All right. Thank you. Did you want to? I wasn't exactly sure how was that just a break in your portion of the proffer, and did you want defense to have an opportunity to address just the financial aspect at this point?
I leave that to the court.
Well, I'm not sure what I thought you had finished, and then Ms. Didell was going to wrap up on the finance side, and then you stood back up, so I wasn't sure what else you had to proffer.
I do have two other things that at this time I want to clarify for the court. First of all, the court asked a question about Michelle Brannon's presence at the Houston location that was behind defense. She did have her own room at the Houston location, although she was located in Tampa at the time of the execution of the search warrants. She had her own room there, and she actually had a crown above her bed, like she was the queen of the organization. I have some information that is difficult to present about her son, but if the court is considering releasing her to the custody of the son, I would like an opportunity to present some information about his involvement in the organization. That's difficult, obviously, as a family member, and so if the court is not considering that, I won't present information. But if you are considering that, I need to explain his role in the organization and some of the things that he's been subject to.
I guess I don't hear the defense saying that that's the main place where they're asking that she be released to. I just think, again, this is just kind of being transparent, and I haven't made a decision yet, and I think we're just going to need to take a break just for 5 minutes just because we've been going for a while, but just both sides kind of know, like what I'm thinking is that the government can identify anyone it wants as a victim, as a person who has been allegedly beaten or allegedly denied food or allegedly denied sleep or allegedly, threatened. And we could put into a bond condition that the defendant has to avoid all contact directly or indirectly with any of those people. And if that were to leave any of the other individuals that she is, if the individual that she's proposing to, reside with don't fall into those categories. And we have conditions that say you cannot contact any of these other individuals. I guess I don't understand why that would not be sufficient to protect them. And if she violates it by contacting them directly or indirectly, then you've got a motion to revoke her bond.
Judge, the government cannot be in a position where it names victims that the defendant cannot have contact with. In a trafficking scheme, the court cannot ask the government to provide a list of victims. That is not, one, public information. Two, it is by its nature an incomplete list. Yes, there are 8 specific victims that the grand jury knows about and returned an indictment, substantive counts regarding those 8 victims. But as evidenced by the indictment and by the brief, there are many, many, many more victims of Michelle Brannons. Many more. Again, some who've come forward and are not ready to release their name, and other people who are considering coming forward. So you're asking the government to do something that it cannot do. It cannot. And the alternative is to release her to the community. I mean, that is just not a viable alternative, and that is not the way the statutory presumption works. The statutory presumption applies to this defendant who has been charged with forced labor, and she's a particularly dangerous individual because of the nature of the scheme and because victims take time to come forward and to feel safe enough and secure enough to come forward because they've been terrorized by Michelle Brannons and terrorized by David Taylor. And in detention hearings, we do not bring trafficking victims in front of the public to testify regarding their experiences. I mean, yes, a trial will come if Michelle Brannons doesn't plead guilty, where that will be the time where they will have to come forward and they will have to face the defendant and tell their story. But they do not have to do that in a detention hearing. And the government is not going to do that to these people and re-traumatize them again. Some of them can't even tell their stories in full yet because they are suffering from such post-traumatic stress disorder that they are unable to fully tell all of the details, just like any victim. They start telling some of the experiences and they need additional time and additional therapy to come forward with additional detail, and that's how traumatized some of these victims are. So Michelle Brannons needs to stay in prison until her guilt or innocence is proven. And at that time, at a trial or by way of a guilty plea, the government will present its witnesses either in private to Michelle Brannons and her defense attorney or in a public forum at a trial. And then a trial jury will decide whether those victims have given enough detail regarding their abuse to convict her. But at this time in a detention hearing, the allegations in the indictment and in the brief and the proffer by the government are more than sufficient to establish that every factor under the Bail Reform Act supports the presumption of detention in this case. And this court should allow every victim of Michelle Brannons and David Taylor's terrible regime to recover and to be allowed sufficient time to process what has happened to them since their release on August 27th, and to give them time and the safe space to come forward and tell their story so that, yes, all the truth can come out and a trial by jury can determine whether the government can prove its case beyond a reasonable doubt. But at this time, we have certainly proven by probable cause before a grand jury the allegations in every paragraph of the indictment. And that indictment establishes, without question, the horrible nature of this forced labor scheme and the crazy money laundering conspiracy that these two defendants were involved in, that literally manipulated donors into donating over $50 million to David Taylor and Michelle Brannons to spend on what? To spend on themselves, on king crab and cars and boats. Not for the community, not for people, suffering in each area of the call center. That is not what they did. Michelle Brannons and David Taylor spent the majority of that money on themselves. They used the fruits of victims' forced labor to live in a mansion in Tampa and to enjoy fancy cars and to have DoorDash delivered. I'm referring to defendant number one. But these are things that Michelle Brannons worked with David Taylor for hand in hand every single minute of every single day. She knew everything that was happening. And what is more terrifying about releasing her is David Taylor, at least, was in Shutaway in North Carolina during the course of this. Of course, he terrorized the victims. Everyone was afraid of him. But he wasn't present with them. Michelle Brannons was present with the victims in Missouri, Florida, and Houston. She was the one who imposed all of the punishment. She was the face that they saw on a day-to-day basis. And she terrified those people who have come forward and told the government their stories.
All right. Anything else before I give?
No, Your Honor, thank you.
Okay, you can go ahead.
It's a very unusual detention hearing, Your Honor, based on my experience, where the government simply regurgitates their theory of prosecution without producing proffered factual information to the court. I've never been a part of a detention hearing in my career where the government has refused to respond to the court and disclose specific facts, which is their burden to do based on the law that mandates the way you decide this case. You've already identified the law. You have quoted Strickland. You have quoted the law as set forth in Mercedes, which is the presumption has been met, according to your comments, with at least respect to the danger to the society based on our criminal history. I will not get into all the other information because I don't need to repeat the very same thing 13 different times as the government has done here today. With respect to risk of flight, there's no passport. There are theoretical church assets that she may or may not have access to, but this court is deemed to rely on facts which have been included in two pretrial services report. There's an indictment that lists a series of assets, two of which my client has an association with. So if I hear the word they one more time, every time Ms. Cohen says the word they, it is further evidence of the thin case they have with respect to factual information proffered with respect to this human being, not a whole global church that is protected by the First Amendment, but to this individual. So once the burden is made, United States v. Strickland clearly says, although the defendant's burden of production is not heavy, he must introduce at least some evidence. We've done more than that. And so all we've listened to for the last 20 minutes or more patiently is the government's regurgitation of their disgust based on information in the indictment with no factual proffered information that satisfies a denial of bond. I, too, would again simply urge you to follow the recommendation of two independent agencies, your own pretrial services report and the pretrial services agency in the Central District of Florida, and impose the conditions that you deem are appropriate in this case. And I'm glad to speak to those conditions once you've made your decision.
All right. I just want to take 5 minutes unless there's anything else by the government. Is there any?
I can read additional text messages if you want, Your Honor, but there are a plethora of them. I could go on for hours. I don't believe that is what you're asking for. What you're asking for is witnesses to be presented on the witness stand.
That is not what I'm asking for. I'm asking for factual details that establish that this defendant is so dangerous that she cannot be released. And I'm just not sure that things like her one second.
So you're,
That her in paragraph 47, that she told victims if they leave, they would be met with divine judgment in the form of physical harm and eternal damnation. I'm just not sure that her saying that to individuals means that she's such a danger that if we have a condition that she not communicate with those people, that she can't be released on a bond. And so I was giving the government opportunities to present factual detail that might show that she is would be a danger even under the very strict conditions of pretrial services recommendation.
So let the government be clear, Your Honor. As the allegations in the indictment state, there are a number of different types of physical harm that occurred in this case. Michelle Brannons ordered, as did David Taylor, assaults of individuals.
What does that mean? What do you mean assaults of individuals? When? What type of? Where? What are the? When you say assaults, because it also talked about getting in their face and humiliating them and screaming, and not obviously that's terrible if that happened. That doesn't necessarily mean that if she's on like house arrest somewhere and not communicating with any of those people, that she'd still be a danger. And I just haven't heard the factual details, I think, that would rise to the level of clear and convincing evidence.
Well, it is the government's proffer, Your Honor, that victims in the indictment were either physically assaulted or witnessed the physical assaults of other people in the organization.
All right.
That will be their testimony, and that is what was heard by the grand jury. But those witnesses and those victims are not going to come to a detention hearing.
Again, I wasn't asking for them to be here. I was asking for details. And to say that a person will say that somebody was assaulted, that doesn't give me a lot of detail. Doesn't tell me when, doesn't tell me exactly what happened, doesn't tell me what her involvement was. So, I mean, we've been long enough. So the court is governed by the Bail Reform Act, which provides that the defendant in federal criminal cases typically is to be released on bond. That's the default in typical cases. However, in certain cases where the charges are involved the most serious type of allegations, there is a presumption that instead of bond, the defendant should be detained. It is just a presumption, though, and the defendant has an opportunity to rebut it by proffering evidence about his or her background or other aspects of his or her life that would rebut the presumption. And if the defendant does that, the presumption still exists as a consideration for the court, but then the court moves through all of the factors. And so here, clearly, the presumption applies because the indictment stands for probable cause that their defendant violated these statutes. The forced labor one giving rise to the presumption, and so it applies. So then the court turns to the whether the defendant presented evidence to rebut the presumption. I think she did, just in not having any criminal history in 50-some years, rebuts the presumption in and of itself. In terms of being a risk of non-appearance, I gave the government every opportunity to highlight some other significant avenues of monies that she has ready access to that she could use to flee, and the government really wasn't able to do that. It sounds like the government has already seized all or most all of her accounts. And as the government indicated, it had already started pursuing liens on the properties. And the one account that the government said she did have, the crypto account, which frankly is kind of concerning because that can be difficult to trace, I think, and that. But the government admitted it had $35,000 in it. And so I think that also is a proffer by the defendant that there's not a, in terms of risk of non-appearance, that rebuts the presumption that she would be a risk of non-appearance. So then going through the factors, the first factor is the nature and circumstances of the offense charged, including whether it's a crime of violence or some of the other ones don't apply, but certainly the crime of violence would apply in terms of just the charges. The nature of the charges are very alarming. It's very clear that as the government has portrayed this, I would agree, this does not describe a church in the common sense in terms of an entity that seeks to do good for the community and raise money for those in need. It seems much more like a cult. I think that would be a fair term for the description in the indictment. But those are only allegations, and so the court has to bear that in mind. And so the first factor, it does weigh in favor of detention. The second factor is the weight of the evidence against the defendant, not in terms of her guilt or innocence in the case. She's presumed innocent in the case, but the weight of the evidence that she is a danger and would be a danger if on bond. And I think that's just really where the government falls short, is that I just don't have any sense as to why she would pose such a danger if released on bond with these conditions that she not be involved in communicating with any of these people. And I never was asking, just to be clear, for anyone's name, any victim's name, or to put to victim blame or anything like that. But the details are what is required to show that she would be dangerous even with these conditions. And when you look at the indictment and you look at the comments of the government counsel here today, it was all just extremely vague and about what her involvement was and how she would continue to pose a danger. And so I think the weight of the evidence of the defendant being a danger if on bond favors release. I think also the weight of the evidence of her being a risk of non-appearance if on bond favors release for many of the same reasons I indicated. Her assets have already been seized, and to the extent that she has the potential to get future assets from this kind of ongoing operation, number one, I think that's kind of speculative, but number two, I think we can fashion bond conditions. Again, if she's not allowed to communicate with these people, there should be an ability to greatly restrict that kind of concern. She can be on other kind of conditions that would ameliorate concerns about risk of non-appearance. And so I just don't see her passport's been taken. There's been no proffer about her having family overseas or things like that. The third factor is the history and characteristics of the defendant. And really, all we have is the allegations in the indictment that about her history and characteristics. And if they hold true, they are certainly very alarming. Anyone that would be involved in any way in treating people the way that is alleged in this indictment is reprehensible. But they're only allegations. And so, and again, that's why we have this opportunity for the government to present greater detail about what makes this defendant dangerous. And again, I point to just her lack of criminal history. She has some family. I know the government had indicated maybe a concern about some of her family, and that's fine if there's some, as I said all along, if there's some particular individuals that she would not be safe to be in communication with, we can address that. I think we can address that in any number of ways that also respects those individuals as victims and don't necessarily have to identify them by name. But I just think that that the government's factual proffer has just really not risen to the level that's needed to sustain its very high burden. It's a very high burden to show by clear and convincing evidence that there's no conditions of bond that could reasonably assure the community's safety. And I just don't think that the government met it here. It is a lower burden to show that she would pose a risk of non-appearance, so much so that no conditions of bond could address that. And again, for the reasons I indicated, I don't think the government has met that burden either. The last factor is, would the defendant's release on bond pose a danger to any particular person? I think certainly that could be true, and that's why I've indicated that I'm willing to consider any reasonable way that the government can tailor these conditions to not just minimize, but ensure that she will not have contact with the people that the government is concerned about. And I think that the fact that there are some of her individuals here that the government would maybe characterize as victims, but who are sitting here and have traveled here to support her, show that there is at least some level of disconnect between all of these 57 people in terms of who she really should not be permitted to have any contact with whatsoever, and others with whom she could have contact with and still not be an unreasonable danger to the community at large or to those people. And so for all those reasons, the court will deny the motion to detain the defendant. And I would just go through these bond conditions, which, as I said, are very extensive, and I'd be happy to consider any other ones that the government might want to add or tailor to address any other concerns. You want me just to read them first, and you can we can address those after, or I don't know if you. I know you just stood up. I didn't know if you wanted to address that issue.
I just wanted to be sure that the court knew and that the defense attorney knew, and Michelle Brannons knows that the government will be asking for a stay of its release order in order to appeal. So the government at this time will not be presenting a list to the court as indicated prior. That would not be appropriate, and it is literally impossible to do. So I would just leave it at that. The court can impose the conditions that it's going to oppose, and the government will ask for a stay and appeal the order.
All right.
Your Honor, and the defense objects to that request. The government had every opportunity to assemble a document, file it under seal, be specific. They've been sitting on a 2.5+ year investigation. They know who these individuals are. The stay of this proceeding is an undue punishment to my client and this court's very decision. We waived a reserved detention hearing. She's had a heart attack while she's been in custody in Florida. The government's well aware of the accuracy of that. So any potential stay is to the detriment of her physical health and well-being moving forward. And so we object to that at this time.
All right. And I'm sorry, I should have indicated also, I do think that her physical health is a valid consideration for the court. I think that it's, frankly, I'm much more focused on what I view as the adequacy of the factual presentation, although I think that is an additional consideration. It was on my mind, so I just mentioned that. But I will grant the government's motion for a stay. I recognize her wish to have this matter resolved right here, right now. But I also recognize that the charges, as I said, are very serious overall, and I think that it's certainly a valid, a reasonable request by the government to ask the court to stay it for some short period of time. How much? Maybe like until tomorrow, close of business. Does that give you enough time to file whatever you might need?
Your Honor, there are some complicating factors. One, the assigned judge is Judge Berg, so the government is currently unaware of his schedule. It is also there is also a holiday beginning tomorrow that may impact a number of people. So there are some complicated factors here. The defense attorney, I'm aware, is from out of town. There's government counsel here from out of town as well.
Do you want to see if Judge Berg's available right now?
I would be happy to do so, Your Honor.
All right. Why don't we just take a 5-minute break? Edry, if you could just try to get Judge Berg's chambers on the line and let them know that they might be coming up to see them now if he's available.
All right.
Thank you very much.
All right.
Thank you, Judge.